We have the Public Service Commission has filed this writ appeal against the judgment dated 21st of April 2022. But this, what has happened, Bharat, in this matter, Bharat, before taking your lordships to the impugned judgment, Bharat, few facts are relevant. Here, Bharat, we have conducted State Forest Examination 2022. It's a preliminary examination. So, Bharat, after completion of that examination, we have made publication of model answer key and we invited objection from all the candidates. We received 99 objections, my lord, with regard to question number 81 of set A. We placed all those objections before the subject experts. They decided it and they said that the model answer of Public Service Commission is proper and based on the authenticated text. So, my lord, that decision was taken by the subject expert. Now, my lord, as many as 8 candidates, 8 writ petitions, they were filed before the learned single judge. In these 8 writ petitions, my lord, in most of the writ petitions, my lord, candidates have waived their option of raising an objection before the subject expert. It is when they declared unsuccessful in the preliminary examination, they preferred a writ petition and said that now these are the authentic texts and the court may take into consideration these texts and invited the court to sit over the opinion of the subject experts. In few writ petitions, my lord, they have submitted their objection, but they have not challenged the decision taken by the subject expert. Now, this is the situation, my lord. Now, what learned single judge has done by the impugned order, my lord, the text provided by the petitioner, that has been taken into consideration. And learned single judge has reached into a conclusion that the text provided by the petitioner is proper, whereas the decision taken by the subject expert is not correct. And therefore, PSC should revise the result. PSC should give them additional marks. And since the main examination we have already conducted, so, my lord, we have also been directed to hold a special examination for these petitioners. So, with this backdrop, I would like to invite your lordship's kind attention to page 21, where the yes. No, man. We have said that their objection is not proper. We rejected their objection. Yes. So, your lordship may kindly appreciate. There is a decision of your lordship. Yes. Yes. What has happened, my lord? We have, the subject experts have relied upon the text provided by the state of MP. But the question, yes, my lord, I'll just invite your lordship's kind attention to page 34, my lord. And for the convenience of your lordship's, my lord, I'll read it. In view of the above discussion and taking into consideration a fact that in relation to a subject in the concurrent list, the data of Union of India will have supremacy over the data of state. These writ petitions deserves to and are allowed. It is directed that the petitioners and all other similarly situated persons who have filled option D above 30% as the answer to question number 81 as per set A and similar option in identical question in different seats, that what percentage of total forest area of Madhya Pradesh teak trees are found will have to be awarded marks, and if after award of marks the petitioners qualify for the main examination, then they be permitted to participate in the main examination either by issuing them the roll number or entry pass or by holding the separate examination as the case may be, in as much as it will not be out of place to mention that hearing of these writ petitions was delayed on the request of the Madhya Pradesh Public Service Commission, which sought time when the matters were listed before this court on 12th of April 2022. In above terms, these writ petitions stand allowed and disposed of. And then, my lord, let the order being passed today, transmitted by the Registrar Judicial, through email to the Madhya Pradesh Public Service Commission, and a pre-typed copy of this order be supplied to the counsel for the petitioners, government advocate for the state, and senior counsel for the respondent, Madhya Pradesh State Public Service Commission. Let a copy of the order dated so and so, passed in WP number, be retained in the record of connected with petitions. Here, your lordship may kindly, well, my lord has already dealt with almost the similar issue, my lord. And my lord has dismissed the writ appeals by holding that normally, my lord, the court cannot sit over the opinion of the subject expert. My lord, this is the judgment, my lord, I would like to place for perusal of your lordship. I'm so highly obliged.
I'm taking notice on their behalf. My lord? Yes, my lord. It may be heard, my lord. Yes, my lord. Yes, my lord. What is it? My lord. Yes, my lord. My lord, there is glaring mistake on the face of record. The question was palpably incorrect. The answer given by the PSC is palpably incorrect, my lord, and therefore the honorable single judge has entertained the petition, my lord. The kindly peruse the, my lord, the data given by the state of Union of India, my lord. In the data given by the Union of India, my lord, it is clearly mentioned that the forest cover of teak trees in state of Madhya Pradesh is 30%, my lord, and therefore that order has been passed by the court, my lord. They are relying upon old data, my lord. The recent data of the Union of India was published by the Union of India on their website, my lord. And on relying upon these data, my lord, my lord, well, when there is palpably something in, well, when there is something glaring mistake on the face of record, my lord, the court can interfere, my lord. In the similar case, my lord, identical case, my lord, the recent judgment of this honorable court in the case of, my lord, Aniket Tiwari, my lord, in para 12, the divisional bench of this honorable court has held, my lord, that in a competitive examination candidates cannot be made to suffer on account of the errors committed by the examining body, and to avoid any such gross injustice, revaluation can be directed. Such revaluation and revision on the ground of incorrect model answer key should not be limited only those candidates who have approached the court, but should be extended to all candidates, because the fault did not lie with the candidates with the examining body. If for any justifiable reasons some questions are deleted and marks are redistributed, uniformly given benefit to all candidates, then the same cannot be said to be arbitrary and irrational. Even if the rules do not permit revaluation, the court may permit the same only if it is demonstrated very clearly without any inferential process of reasoning or by process of rationalization in rare or exceptional case where material error has been committed by the examining body, my lord. In this case, my lord, the material error has been committed by the Supreme Court has also held in the series of cases, my lord, that if there is a material error on the face of record, in exceptional cases, the court can interfere, my lord. My lord, kindly peruse the data of Union of India, my lord. There is clear cut, it was mentioned there. My lord, the Union of India also conduct the survey and the state government also conduct the survey. And as per the survey of Union of India, there are more than 30% of forest area of Madhya Pradesh is covered with teak forest, my lord. Para 12, sir. Para 12, sir.
And Yes. जी 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 state, yes. We'll take note of it, madam. We'll take. जी 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 I'm okay.
My lord, in this case, the respondent was removed from service.